has deadlines, but I just wanted them to just briefly say what their background is and what they did on this, just so you have an idea of the quality of people working on this.
Okay, my name is Art Borchers. I work for Larson Forensics. I'm retired from the Oak Park Police Department, where I was a crime scene tech and detective for 30 years. And my part in this was looking at the video from the Shell station and the various photographs that were and weren't turned over, as well as the investigation about the silencer, or use of a silencer, or a lack of use of a silencer in this.
My name is Perry Myers. I'm president of MSI Detective Services. I was brought in to conduct investigation background, research witness statements, and we were able to refute many things that were entered in as evidence during the trial. We chased down witnesses. We got witness statements of people who told police certain things that would have helped to exonerate Marni, and they were ignored at the time. And worked on the Shell gas station video, basically able to refute that, to prove that that was not the vehicle that Marni rented. Determined and verified the reason why Marni rented the car, and we also examined phone records and cell phone tower records. There's a lot more, but it's 3 years, so that's kind of the highlights of it.
My name is Lee McCord. I'm a licensed polygraph examiner for the past 44 years. I administered polygraph tests to Marni, her father, and her son.
My name is Daniel Connedy. I'm a retired special agent from the U.S. government of Homeland Security. I'm a firearms expert. I was brought in to determine whether products that Marni purchased at Home Depot could have been used to construct a usable and workable suppressor on a gun that she had at some point in time.
My name is Jax West. I'm an advocate for the wrongfully accused. I have a Facebook group called Stephen Avery Project, which is one of the cases that I advocate for, and that I also do the social media for the Marni case.
My name is Dominic Izzo. I'm a retired police officer from the village of Wrongful Park. I was involved in a parallel case and brought into this one very late on to liaison between some of the officers that were there during the time of this case.
My name is Steve Opino. I work for MSI Detective Agency. I was the lead investigator on this case. I was involved with timelines, witness statements, dealt with Sean Gale, a lot of witnesses, and we dealt with very closely with law enforcement as well.
For the defense.
I'm sorry?
For the defense.
Correct, the Marni unit.
And then, you know, as we're waiting for Jed, hopefully he'll be here any minute. This is Marni's family, and if you guys just want to introduce yourselves briefly.
I'm Brandon Yang, and I'm her youngest son.
I'm Larry Morar. I'm Marni's father.
And my name is Andrew Yang. I'm Marni's oldest son.
How old are each of you?
They're just introducing, we've introduced everybody here in their background, just so everybody first know. Look who's here.
Good morning.
Well, good morning. My name is Jed Stone. I'm a lawyer. I represent Marni Yang. Today is International Wrongful Conviction Day. celebrations and actions are going on around the world to free innocent people from wrongful convictions. It's my great pleasure, great privilege, to represent Marni Yang in her efforts to overturn her wrongful conviction. As many of you know, Lake County, Illinois has become the epicenter of wrongful convictions in the United States. Marni's case is a textbook example of that kind of wrongful conviction, prosecutorial misconduct, police misconduct, trial errors. Yesterday, we filed a long in the making petition for post-conviction relief, alleging Marni's actual innocence. I think what I want to say today, more than anything else, is that there are many good and honorable men and women in law enforcement, people of integrity. There are many prosecutors who are fine, outstanding humans and people of integrity. But there are a handful who make rotten the process and create injustices in their wake. I know that there are fine people in the Lake County State's Attorney's criminal justice system. We've uncovered, I think, the surface of the corruption of this case. And I would urge any law enforcement officer who has information, any prosecutor who knows how this process got miswrought, misshapen, and resulted in Marni's wrongful conviction, to come forward with further information. We're going to have a hearing on this matter. We're going to reverse this conviction. And I think that we are on the right side of this question. This morning, we're going to hear from some of the experts who have joined me in this struggle for justice. Just a word about that. I'm just the lawyer, I'm just the spokesperson. The real work in this case is done by investigators and scientists and family members, by polygraphers and firearms experts and former FBI agents and police officers who reconstruct crime scenes and understand the science and the ballistics of this case, by investigators who, doing traditional gumshoe investigations, go out and talk to witnesses and learn facts. That's what this case is about. And had that work been done pre-trial instead of 9 years hence, we might not be sitting here today. But here we are. So let's celebrate International Wrongful Conviction Day with the first step towards the final chapter of this wrongful conviction and the ultimate release of this innocent woman. Our first person is going to be Perry Myers, who is an investigator. He's going to talk to you about the stolen gun and the shell videotape.
Can you spell your name for us, please?
My name's Jed, J-E-D.
Yes.
Stone, S-T-O-N-E. His name, he'll spell.
Perry, you're gonna have to move over to the
Okay.
mic.
Just move your chairs, you guys just part ways, and then we'll stand in the middle there.
Let him sit. Perry can sit.
My name is Perry Myers. I'm the president of MSI Detective Services. We were hired in this case to...
Spell your name, spell your name.
I'm sorry, M-Y-E-R-S.
Harry P as in Paul.
P as in Paul, E-R-R-Y.
Thank you.
We were hired about 3 years ago to begin investigating this case, and as I mentioned before, there are many, many things we looked into. Like every case I get in, I look at it and I have to be objective, although you always hate to see when something like this happens, so you don't think that the police and the prosecutor made a mistake, but I'm convinced they did. A couple of the things that I'm gonna talk about are the Shell gas station video from the security camera located at Waukegan and Osterman Road. The gas station had a security system that was put there for the purpose of watching their gas pumps, but it happened to capture the intersection where a black vehicle drove through at about the time of the murder, or just before and then just after. It was a Volkswagen Rabbit, 2007, black, that was rented, and at the trial, the video was introduced and allowed in. It was stipulated to that this was in fact a black Volkswagen Rabbit that drove through that intersection. It was not a black VW Rabbit. We proved forensically that this vehicle, which we could not identify due to the poor quality of the video, was something other by renting an exact vehicle. We rented a 2007 Rabbit, which was difficult to find. We found it. We put video equipment that was exactly the same as what they used at the time, and we were able to compare it. Now, this video, this picture is a snapshot of what the state used at the trial. This is their vehicle. What they represented was a VW Rabbit. This here is the real video snapshot of a VW Rabbit. That, you can see the body styles are not the same. It's not the same car. Other questionable things about this is we don't have any record of when and how and by who the video was obtained from the gas station. For all we know, this could have been done a month later, could have been a different time, everything could have been set up. We don't know. There's no chain of custody, there's no information. We do know at the time that the video system, because of the age or how long ago this was, that the video system could not be, couldn't save video off of it by either USB or by network. You had to go and play that video into another device. We don't know what that was played into. We don't know who did it. The other matter, and I know some of the experts are gonna speak in more detail about the .38 Beretta that Marni did own at one time. She received the gun as a, one of her relatives passed away, she inherited it, had the gun. She was not a firearms expert, but she had possession of it. About 6 months prior to the murder, I was able to obtain the statement of a person who confessed that he stole the gun and he stole a Sony PlayStation in order to pay off a debt that he owed. The police approached him, not because of that, but because they wanted to get information, family friend, and he thought that he was going to be arrested for theft. So he confessed to the police officer who was taking a statement and said, "I'm sorry, I did take the gun, I stole it, I took the PlayStation." And the police officer said, "We're not here to talk about that," and totally ignored all of that information. If that information was put into the report, they would have known that Marni didn't have possession of the 38, I'm sorry, 9mm at the time. So we've got that statement, and I'm gonna pass this on to someone else.
John, if you would come up and talk about trajectory and bullets. This is former FBI agent John Larson. He'll introduce and spell his name.
stand behind?
Yeah,
You're
sit
gonna
back,
need to
please.
for the microphones, yeah.
Okay. Excuse me. Yeah. Morning, everybody. I am John Lewis, Louis Larson, Larsen. I have a company called Larson Forensics and Associates. We're out of Glen Ellen, Illinois. We specialize in shooting scene reconstruction, both for criminal and civil cases, and traffic accident reconstruction. I'm a retired agent, and I was responsible for running I was a senior team leader for the evidence response team in the Chicago division for most of my stay in the Bureau, and I was their coordinator. My job and responsibility in this case, our company was to look at the height of the shooter. That was the marching statement. What is the height of this shooter? The two pictures in front of you here, we use lasers. We try and take and make this a very objective examination. The background for setting this up was the medical examiner's report and the crime scene photos and pictures and documentation of the scene by the Lake County, Major Crime Task Force. I think when you're looking at the picture with the lasers going across it clearly defines that the top beam you're looking at on the photo represents someone who is my height or taller, 5'10" or above. And if you notice the angle is going down, there's a drop and it's going across the body, in this case, Ms. Wright's body, and it's coming out of the left shoulder area. The lower beam would have been if Marni Yang at 5 foot had shot. And if you're looking at that one, if she were shooting, the beam would be coming up and through the shoulder. As it is, it's not. It's pretty definitive. We figured out that this was the first shot based on clothing and she wore. This is close to contact. We can't say it was contact, but we determined that it was very close based on powder patterns and the burning of the fabrics and stuff. But I think when you look at the two images, you can see for yourself that the 5 foot shooter could not have made that trajectory path. And the one image that's in silhouette, the only reason I brought that was because so many times we look at the background, we get distracted about what's really there. And if you draw a line from the red dot coming from one side and going through the body, you see that again. What's the angle? The angle is coming down. And the medical examiner's findings were articulated in such a way that this mirrors their findings. And everything we base ourselves on, it's very objective. There's no subjectivity in this. That's it.
Thank you. I think it's important to remember that in every homicide, certainly in every homicide I've ever been involved in, there are victims and unspoken victims. And today we have the sorry privilege of hearing from Marni's family. I'm not comparing loss. The loss to the Ryder family is unspeakable. But let's not take our eye, especially on International Wrongful Conviction Day, off of the damage done by the prosecution of innocent persons and the lengthy incarceration of an innocent woman, and the damage it has done to her father and to her children. You're going to hear today from Andrew Yang, Andrew, and from Emily, and from Larry Merard, the father of Marni. First, Andrew.
So, I'm the oldest son of Marni Yang. Back when all this was going on, my mother was forced to basically confess to something she didn't do. And that was only because the Lake County Task Force put so much pressure on me to basically confess to it also. I had nothing to do with it. My mother had nothing to do with it. I don't think they cared if we did or not. They just wanted a conviction. During that time, a lot of stuff took place. They snatched me from my home. They picked me up off my school grounds. Mind you, I was 16 at the time, a minor. When they had took me into interrogation, for the few times that they did, I asked for a lawyer. I was denied one. The damage that they did to me, well, I don't think I'll ever be the same. I've come a long way since then. With all the pressure and the torment from them, you know, I started getting involved with heavy drugs. I landed myself into like a psychiatric unit, on a psych ward unit, just to kind of get away from everything. I couldn't take it anymore. You know, I was on the verge of either, you know, just ending it all. You know, I don't think any kid at my age should have to go through what I went through. I know there's something new on Netflix called When They See Us. It's a story on the Central Park 5, and exactly what the police did to those 5 boys was what I went through with the Lake County Task Force. And you know, it's sad because I'll never get back any the damage that they did. I'll never get the same, basically. You know, I just want my mom home. I want her life back. You know, things just need to be set right. The truth needs to be set. And you know, I think that's what we're all doing here. All the experts, investigators, just to bring my mom home and bring justice to whoever's really out there that committed this crime. And basically that's it. That's not my sister.
Thank you, Andrew.
Thank you.
Emily?
I'm Emily Yang, Marni's daughter, the firstborn. What the police did to my brothers and I was wrong. I know that they had a job to do, but they went way too far with us. They threatened and manipulated us with lies. And we were only 16, he was just 11. I remember the police coming and raiding our home early in the AM, and they didn't even let me change out of my pajamas. They said, "We're going for a ride," and us to the police station and separated us. They asked me if I knew anything about the day of the murder, which was months earlier, so I couldn't remember details from that date. I wasn't even aware of the murder. Then they continued to tell me that my brother and my mom committed this crime. At that point, I just went into shock. They continued to ask me the same questions over and over and over again. I had no idea what they were talking about. This went on for hours and hours. And after so much frustration and mental exhaustion, it completely broke me. I started banging my head on the table. And at that point, they kind of lightened up on me and then dug into my past and found out that I hadn't seen my father in over 8 years. They told me that if I had written a statement for them, they would find him for me. I didn't think that I was gonna see my family again, and seeing my dad or hearing from him was a miracle to me. So I wrote what they wanted me to write, which was that I witnessed my mom writing letters to Sean's 16 other girlfriends, which wasn't true. Eventually, they found my dad and gave me his number. And when I finally did call him, he told me, "F you. Don't ever call here again." That was the exact opposite of what they told me that. They told me he wanted to see us. I had to testify in court 10 years ago of my testimony. Before I went into the courtroom, a woman came in and told me, "Hey, you're gonna testify, what your statement was." And I told her, "I can't do this, it's not true." And she told me that I'd get in really big trouble if I didn't testify what I wrote. And I went in there, and it turns out that the woman was the prosecutor.
I have still the interior options are available, but the exterior options are not.
When you're in those moments of the eyes of the storm, you're not really aware of everything that's happening or going on. Now that we're older and, after seeing how they see us, we kind of gain a perspective of what happened and what was done to us. The way the media portrayed my mom, some violent, jealous woman, that was not her. That was not the mother that we knew. She was loving and supportive of all three of us. She was a single mother who had 3 jobs. was just a one person. We just want to like that.
Thank you. Larry?
I'm Larry Marar, Marni Yang's father. That's spelled M-E-R-A-R. Seeing my daughter life in prison for a crime she was incapable of committing based on the evidence in hand is incomprehensible. The Lake County Task Force being allowed to abuse minor children and ruin their lives is an outrage. You know, we're asked to believe in the integrity of our criminal justice system, yet Lake County law enforcement is allowed, permitted, to turn it into a business with innocent people as the bottom line. The 2007 high-profile murder of Ronnie Reuter and her unborn child remained unsolved. Empty-handed, the Lake County Major Crimes Task Force targeted and laid siege to Marni and my grandchildren for close to 2 years without looking at any of the other witnesses, viable witnesses that they had. When they were unable to implicate Marni in the murder, they fabricated a crime theory, if you will, manipulated evidence and witnesses in order to solve the problem, and they sold that to the media, the judge, and the jury. Late February 2009, my wife and I were downtown attending the opera, and Marni called me all upset. The Lake County Police had confronted her friend Christy Passion and intimidated her with her complicity in the crime. In other words, she knew about it, but she didn't come forward. At the same time, she had some new and terrible information to share with Marni. That the judge had issued an arrest warrant for her son Andrew for Tuesday morning for the murder of Ronnie Reuter. Marni said, "Dad, these people have been terrorizing me and the kids for close to 2 years, and we just can't take it anymore. Andrew had nothing to do with this. I'm just gonna meet Christy and make up a story that I committed the murder and let the attorneys sort it out with the police, which they're capable of doing." I begged her not to go, told her that we would go see her attorney on Monday morning, but she was adamant and said that she couldn't stand by and watch them destroy her children, especially Andrew, who was close to being suicidal, or how they were treating him. So, with that in mind, and not thinking clearly, and wanting to protect the kids, she went and met Christy at a restaurant to invent her confession. You know, 2 families have been impacted by this. Our family, of course, and I can't even imagine what the Reuter family was made to endure and to go through with all of this. Ronnie Reuter should be allowed to rest in peace, knowing that her murderer isn't walking the streets free to kill somebody else, for sure. That said, the Lake County Task Force is obligated to properly investigate this crime and the other suspects who had significant motive to commit the crime. What happened was definitely a tragedy, without question, but the killer was not Marni. And nothing will prevent us from exposing this corrupt miscarriage of justice.
He's just gonna grab his mic and then Jen.
Trustee John?
So a great deal of research, social science research has been done on why do people confess to crimes they didn't commit. And a great deal of legal work, lawyering work, has been done on how do you untangle that mess once it's done. Again, this case, the prosecution of Marni Yang, is textbook in answering those two questions. Why do people confess to crimes that they didn't commit? Because they get worn down by police? Because children are threatened, or loved ones are threatened, and they do something stupid like confess to it to protect people that they love? That's what happened. How do you undo it? Well, you undo it with thoughtful, really thoughtful investigative work by these investigators. You look at the words that Marni said in the Christie Passion conversation, and then compare that version, fabricated. You all have, I think, access to a Dropbox. In the Dropbox, there are tapes. In those tapes are two significant pieces of information that got filed yesterday with the Circuit Court of Lake County. One is a tape where Marni says to Passion, "I'm just gonna make shit up. I'm just gonna make shit up." And the other is a tape where Passion leaves the table of Denny's, goes into presumably a bathroom or a private place, and says to her handlers, "I think she saw the wire." Marni did see the wire. She knew that Christie was wearing the wire. So we know that she said she was going to make shit up. And we know that she knew that Christie was wearing a wire. The problem is, the jury didn't know that. Nobody bothered to tell the jury that this confession was made up. Nobody bothered to tell the jury that she knew that she was being wired. I think that's important. But maybe even more important, if you look at the facts that are true from the physical, immutable, forensic science perspective of this crime scene, and compare them to the fanciful, false, made-up shit that Marni told Christie in order to save her son from being arrested, you come to the inescapable conclusion that Marni didn't know what she was talking about and that her confession is a textbook false confession. We're going to get a hearing on this case. We're going to get a hearing because there is evidence of actual innocence. We're going to get a hearing because there is evidence of police misconduct. We're going to get a hearing because there is evidence of a prosecutor suborning perjury. And when those things are proven to a judge, we will get a new trial. And at that new trial, each and every aspect of the prosecution's case will be challenged, and a new result will come. I learned a long time ago, even before I was a lawyer, that things aren't always as they appear. Those of you who covered this case 9, 10 years ago say, well, she confessed on tape. She must be guilty. I'm telling you now, things are not always as they appear. Thank you for coming this morning. Let's go celebrate International Wrongful Conviction Day. And let's celebrate it in the courts of Lake County and bring justice for Marni. Thank you.
Does anyone have any questions?
In particular, Jed, where did the police go? Apart from questioning the family, who were the other suspects that they glossed over in order to move Marni?
You know what, I'm not going to talk about that today. I raise it as the lack of integrity in the investigation in the motion. I'll let the petition itself speak on that. At some point, I think it will be appropriate to focus on those other suspects. But I think that's a prosecution job, not my job. And I'm not trying to dodge your question, but I don't think this is the time or place to do it. Today, we're focusing on Marni's wrongful conviction. Sometime in the future, we'll figure out who the guilty person is.
Jed, can you clarify first, what's the new stuff today that nobody's ever heard?
All right, here's the new stuff. The new stuff is photographs of the crime scene taken by the crime analysts, and the police crime analysts, were withheld from the defense at the first trial. In the course of preparing for this petition, John Larson and Art Borchers discovered that there were references to film. Remember film? It's that stuff that just used to develop in pre-digital days. That film was taken and that rolls of film were discussed in reports. Those rolls of film weren't developed until we demanded their production. When we demanded their production, we found the police using laser shots of the crime scene, and those laser shots are what John and Art based their analysis on. Had that been turned over to the defense originally, we might have had a different trial if the defense had known what they were looking at. But we now know for sure that those photographs and the work of Art Borchers and John Larson proved to a reasonable degree of scientific certainty that Marni could not have been the shooter. That's probably first. Second, there are tapes that the jury didn't hear. I'm gonna make shit up. I know she knows I'm wearing a wire. Those tapes are newly discovered. And maybe even equally important, Marni Yang's phones were court-ordered eavesdropping. Every phone call she made was listened to in a wire room. Every phone call she made. We know that she called both her mother and her father to report that she had heard that her son was going to be arrested and she was just going to go make up a story. I don't think she told her parents she was going to make shit up. I think that was language she used to her friend. We know that those conversations happened for two reasons. Reason number one, Larry tells me that they happened and signed an affidavit under oath. Francine, her mother, tells me that they happened and she signed an affidavit under oath. Those affidavits are attached to our post-conviction petition and presumably in a Dropbox available for you. But we also have logs, because prosecutors can hide stuff, but the government is wonderful about preserving records. If you don't believe me, ask Donald Trump and Secretary Pompeo. It makes certain people very nervous. It makes me very happy. I know that those conversations were recorded, and I know they were heard. And I know that from logs that we have in our possession. What I also know is that the tapes that were turned over to the defense pre-trial didn't have those conversations, the Larry Morar conversation and the Francine Morar conversation on the tapes. We'll find them. But we at least know that they exist now. That's new. The defense, for whatever reason, stipulated to the Shell video. They agreed that that video should come into evidence and agreed that the car in that video was the same make and model as the car rented by Marni. We now know to a reasonable degree of scientific certainty that that is not a Volkswagen Golf.
Rabbit.
Golf?
Rabbit.
Rabbit. Rabbit. Rabbit. Did I just say rabbit? Rabbit? It's not the car. And had that evidence been adversarially tested at trial, that tape never would have been permitted. So those are the kinds of things we know. We know that the state said that Marni shot with a gun that had been in her possession, and that the reason that the noise from the gun didn't alert all the neighbors that there had been multiple gunshots in a confined area is that she had fashioned a silencer for that gun by going to Home Depot and buying homemade silencer stuff. This is absolute folly. There's no such thing. The barrel length on that Beretta would mean that you could not, to a reasonable degree of scientific certainty, put a silencer on that gun. You can have silencers made for the gun. They usually are barrel inserted so that they're not attached. But you couldn't put a bunch of tubing and steel wool and a C-clamp on the barrel of that gun. And we now know that there's no evidence on the clothing or the wound site of the victim that the bullet passed through a silencer silencing material. We know that now. The jury didn't know that. That wasn't investigated. And we don't know why it wasn't investigated. I hope that answered your questions.
Hasn't an appellate court already upheld the conviction, and how do you procedurally handle that?
The appellate court did uphold the conviction, and the Illinois Supreme Court did deny her petition for leave to appeal. I'm trying to think of every wrongful conviction case that ends up getting reversed in post-conviction. Alejandro Dominguez, Juan Rivera, Benny Starks, three that come to mind immediately, all three out of Lake County. Each one of those cases, an appellate court affirmed the conviction. The Supreme Court said, no, thank you. And in post-conviction, each one of those people were exonerated, received certificates of innocence, and are home with their families, each one of them. The fact that, see, the problem with an appeal is that the appellate court can only look at the four corners of the record of the trial. An appeal is only a discussion as to whether or not there were trial errors that would require reversal. The law permits a post-conviction petition, the one we filed yesterday, that goes outside of the four corners of the record of the trial and challenges the evidence and the constitutional processes that brought that record. In our case, the constitutional issues are the right to effective assistance of counsel, the right to due process, the right to be free from suborned perjury, the right to be free from errors affecting the search for the truth. And I guess this is the final thing I want to say unless there are other questions. Trials are searches for the truth. I've been a lawyer for almost 45 years. I've tried hundreds of cases to juries. I love trying cases. And I believe that they are truth-seeking. But only when the evidence is challenged, only when the lawyers do their job, only when the prosecutor doesn't cheat, only when the police don't bully people, then we get to the truth. And when the law catches prosecutors doing that, and when the law catches cops doing that, and when the law catches lawyers abnegating their responsibility, the law has a duty to reverse, remand, and do it right. Another question?
There's a point here, sorry.
I'm sorry.
There's a point here about, there was proof withheld from Nan's attorneys that her Beretta pistol was stolen 5 months before the murder.
Right.
Can you talk about that?
Yes, I can. I mean, that's, Perry talked about that. You may not have been here. There's a fellow by the name of Jesse Delgado who was a friend of the Morar children. Jesse was questioned by the police before the trial. He thought he was being questioned about having stolen the gun and a PlayStation video machine from the Morar house before the crime ever occurred. The police said, we're not interested in that. And although they heard him say, I stole the gun, it never was turned over. There's a case in the United States, from the United States Supreme Court called Brady versus Maryland. Brady versus Maryland says that prosecutors and police have a duty to turn over exculpatory evidence to the defense. The fact that the state had a theory that this Beretta was used in the murder and they knew that there was evidence that it had been stolen months before is classic Brady material. But it interfered with the state's theory of the case, so they just didn't tell us about it. We have an affidavit from Jesse. He tells us under oath, under penalty of perjury, that he stole that gun and he told the police that he stole that gun. And that's the first time we've learned about that, was post-trial. I think that answers your question.
You haven't spoken about the DNA evidence.
There is DNA evidence in this case.
On the shells.
On the shell casings, there are five unspent shell casings found at the crime scene. The inference being that gun fired, gun jammed. Clear it, unspent shell casing gets ejected. Gun fires, gun jams. Clear it, unspent shell casing ejects and ends up on the floor. We took those unspent shell casings to Carl Wright, who is one of the preeminent DNA experts in the nation. And he says there is no evidence of Marni on those shell casings. There is evidence of an unknown male. We, meaning the defense team, doesn't have access to a database of convicted criminals to run that, but perhaps Mr. Nierheim's office will run that DNA profile, and perhaps we'll find out who that unknown male DNA is. And there was evidence of this writer's blood and DNA on the shell casings. That should come surprise to no one. They were on the floor where she had exsanguinated blood. Her blood was everywhere. That's the essential DNA evidence in this case. It ain't Marni's, it's somebody's, we don't know who. Yes?
Jim, this is obviously a very large and thorough investigative effort, and I'm sure some people might wonder how much did it cost and who is paying for it?
It is a blessing to have a father who's willing to mortgage, remortgage, and daughter's freedom. The answer of how much I don't think is public business. You look at the room and you tell me how much do you believe a forensic science lab, an investigator, a polygrapher, a former Homeland Security ballistics expert, a police officer, and a lawyer, plus Carl Wright might cost, and you know it's gonna cost a ton of money. And it's heartbreaking, isn't it, that so few can afford that kind of justice. It's heartbreaking. My little office, as many of you know, I've been as large as a 2-lawyer office in Waukegan, Illinois, hardly the urban center of the world. And my little office has been involved in 9 wrongful convictions and ultimate exonerations. If my tiny office in Waukegan, Illinois has been involved in 9, there must be thousands, if not tens of thousands. Yeah. And sometimes the only thing that separates them from justice is lack of access to a lawyer, investigators, DNA experts, crime labs, and we need to do something about that. That's a good topic to discuss on International Wrongful Conviction Day. I'm done plugging. Yes?
Can you clear up some confusion on my part? When she told her friend in the restaurant that she was gonna make stuff up, and then later the friend said, and she knew I was wearing a wire, why is that incriminating evidence if she knew she had a wire and she was saying something that would clear herself?
I don't understand your question. The jury never heard I'm gonna make shit up. The jury never heard her tell her mother and her father, I'm just gonna do something to protect Andrew. And that was never heard. That got put into a jar, put on the shelf, and the prosecutor hoped would never come off that shelf. The fact that she said, that Passion said, I think she knows I'm wearing a wire, that was never heard. The jury never heard that. I don't know that the judge ever knew that. We'll find out. But I don't know that the judge ever knew that. That was put in a second jar, put on a shelf, and the prosecution hoped nobody will find that out. All that was heard was the stuff that got made up. And nobody told them that it was made up stuff. In fact, nobody challenged it by comparing the made up stuff with what we now know are the immutable facts of the crime itself. She tells Passion that when I shot her, she fell backwards and hit her back on the kitchen counter and went down. She didn't land on her back. Oh, yeah. She landed on her face. She tells Passion her legs were in the hallway, so I had to kick them to get in, to close the door and leave. The photographs of the crime scene show that her legs are far from the doorway. There's no bruising or marks on her legs where she had been kicked. There's no evidence that she had been kicked. It was made up. And we know that from the immutable scientific evidence of the crime scene. So there are instances like that throughout that the jury never heard, should have, but never did. And the 2 things in the jar were never played. I hope that answers your question.
Sorry, just to clarify. So what did they?
You get 2 more questions, but that's all. These guys have other things they want to cover this morning.
So what did they hear? They heard a different conversation, or this was an entirely different passionate conversation?
No, they heard the conversation that was taped at the table in Denny's, but they didn't hear those 2 parts of the conversation.
So you're talking about not just the defense is incompetent in getting this information, but that there was malfeasance on the part of the prosecution, not turning over a lot of this information that they had.
The United States Supreme Court in the 1960s said in Brady versus Maryland, essentially, my words, not the justices, this is not a game of hide and go seek. This is a game of you got exculpatory evidence, you produce it, because trials are truth-seeking. Some prosecutors believe that this is a game of hide-and-go-seek. They are wrong, and the courts will tell them so.
One final question? Everybody got what they need? Okay, thanks. Thank you
you very
everybody
much.
for coming. Does anybody else need this? This is kind of a summary of the new evidence.
No, it's fine.
Oh, I just wanted to text them
I know, Rob's just texting me, so.
Oh, great, great.
I'm literally on my way out. 5 days to go to Denver.
Oh, no.